webinar. Today's topic is the three-headed monster that you see on the screen, workers' comp, FMLA, and ADA. Our presenter is Dave Wilson, founding partner of Hirsch Roberts Weinstein, a preeminent employment law firm in Boston. Our webinar will be recorded and will be available on the CIP group website, askcip.com. We anticipate the webinar will be approximately 45 minutes long to allow a question and answer period following the presentation. If you have a question, please enter it in the question pane located on the right side of your screen. We'll try to answer as many questions as we can in the time allowed. Thank you for joining us today, and Dave's presentation will now begin.
Thank you, and welcome everybody. And feel free to ask questions, type in questions anytime, anytime you like. The reason we call this the three-headed monster is this is the way you need to look at leave options, and you can only attack the monster one head at a time. So the first is somebody gets injured at work, they go out on leave. And the first thing you're dealing with is what we call the FMLA. Remember, the Family Medical Leave Act. Then once the FMLA is done and their 12 weeks are done, you chop the head off that monster, and then you turn to the ADA. And once you address the ADA issues, the last potential issue that still may be out there is workers' comp. And so we're going to sort of cover all those today. There are also going to be some scenarios and polling questions where you can write in, and I'll get started right now. So first is, when you think about leave and disability-related laws, we've got the FMLA, 1990, the ADA, which I believe is 1996, the Mass Fair Employment Practices Act, and that's just the 151B, the anti-discrimination law. We've got the Mass Workers' Comp Law, which is Chapter 152, the Mass Parental Leave Act, which was an upgrade from the Mass Maternity Leave Act in the last couple of years. We also have to think about breaks for nursing or breastfeeding. And then finally we have GINA, which is the Genetic Non-Discrimination Act. And these are all come into play in these types of situations. So as I said before, we have to attack any leave situations one monster head at a time. So we're going to start with the FMLA. And again, what is the FMLA? So the first thing, it's unpaid job protected leave. Okay? It's unprotected leave. So who's covered? The first question always is, who's covered? Am I covered as an employer? Do I have 50 more employees or 20 or more work weeks preceding year? So somebody needs to put themselves on mute. Okay, and then so employers, they have to employ 50 employees within a 75-mile radius. A work site is assigned as a home base from which the work is assigned. And so, for example, I may be the sole employee in Kansas City, Kansas, but I report to a Boston office that has 80 people. That would be considered my work site. And so remember, it's job protected leave for up to 12 weeks of time. So first, am I a covered employer? Yes. Then the second question is the employee eligible? So first off, have they been employed for at least a year? And during that year, did they work at least 1,250 hours? So 24 hours a week, or if they're working 40 hours a week, that would be the equivalent of about 31 weeks. And do they work at a site with 50 or more employees within the 75-mile radius? Now, 12 months can be calculated whichever way the employer determines. We like the rolling calendar year, so you're looking back 12 months from the day they request the leave. Remember that military service counts, and employment prior to a break in service of less than 7 years counts for those in the military. All right, next, what do we have to provide if we are covered employer and they are a covered employee? Well, we have to provide them with 12 weeks of unpaid leave. And what are the reasons? Well, for birth, adoption, or foster placement, for their own serious health condition, for the care of a child, spouse, parent who has a serious health condition, or somebody who is in what we call loco parentis. That is somebody who may be living with you, for example, but they're not a child, a spouse, or parent. And then there are, for people in the military, it can be up to 26 weeks, and there's a whole section on that. And if people have specific questions about the military, we can deal with those later. So then, what are the employer's obligations? Well, we need to give the employee notice if they've asked for this time off, and it qualifies under the FMLA. We want to give them notice. We want to find out if they're eligible. So we give them. There are a number of government forms that we give them. And here they are listed here. And then they have an obligation to get those forms filled out and returned to us. And so, let's just go over those forms a little bit. The written general notice, that's to all employees. It's in your handbook. It's a poster. It should be a poster that you have up in a conspicuous place. If you don't have that, you need to get it and put it up. The eligibility notice is when the employee requests or when the employer acquires knowledge that the leave may be FMLA qualifying. The employer must notify the employee of their eligibility to take the FMLA leave within 5 business days. And then we recommend you use the Department of Labor's Notice of Eligibility and Rights and Responsibilities form and have them, get that to them within the 5 days and then have them fill it out. And that form includes the what the leave is designated for, whether it's counted as FMLA leave, and the like. And then they have to get it filled out and returned to you. And at that point, you make a determination if the leave is approved or not. Now, in addition, even though it's unpaid leave, one of our obligations as an employer is that we have to maintain their health benefits on the same terms and conditions as if they were continuously employed. So, for example, if I paid 20% of out of my weekly pay, there was a 20% payment that went to my health insurance, I'm supposed to continue to make that. An employer and the employer are supposed to try to make arrangements on how to do that. Now, sometimes I'll say, look, I don't have the money, but I've got vacation time, so can you take it out and deduct it from vacation time I have? That would be an example. Now, often, if under the Mass sick leave law, those first 5 days I'm out, they could be covered, and I might be able to use it for that purposes as well. The employee can choose. Now, here's a good point. The employee can choose, or the employer can require substitution of accrued paid time, such as vacation and sick time. However, there is an exception to that. And so when leave is taken pursuant to, say, a disability plan, then the employer can't require them to use that. So if I'm getting short-term disability, for example, you can't require me to also be using my vacation at that time. Now, the employee may want to, and they could agree to, look, I'm getting 60% pay on the disability. I want to use some of my vacation to get me up to 100%, that other 40%. But the employer cannot require in that situation. Okay, now the employee wants to return to work. And so one of our obligations is it's job protected leave as long as it's within that 12-week period. And then if they return, we have to return them to a equivalent position. Now the regulations talk about it be virtually identical. So they must be reinstated even if the employee was replaced or the position was restructured to accommodate the leave. And they must get any unconditional pay increases or bonuses. Now, that doesn't mean we have to pay them while they were out, but it just means that if everybody who, let's say they were a welder and they went out and all the welders got a pay raise, when they come back, they also get that pay raise. But you'll see in the last bullet, if a bonus or payment is based on the achievement of a specified goal, such as hours worked or something sold or perfect attendance, and they haven't met that goal due to that leave, you don't have to give it to them. So now the employee wants to return to work. There's 3 instances where reinstatement is not required. One is if they're a key employee, and they would have to be one of the top, I believe it's 10%. They have to, their pay has to be in the top 10% of the company. They would have, now the other thing is the FMLA says you're not entitled to any greater rights than you would have gotten if you hadn't gone on leave. So for example, if we go back to our 16 welders that we have, and we decide we're going to outsource welding and wipe out our welding department, well, I'm out on FMLA leave as a welder. I don't get to come back and say, hey, you still have to bring me back, even though you've wiped out the rest of the department. So you're only entitled to as greater rights as you would have had if you were still employed. So if you would have lost your job, even if you hadn't taken the leave, and the employer, the burden of proof is on them to show that, then they don't have to bring you back. And then also if you've taken the leave fraudulently. But before you decide if somebody's taken the leave fraudulently, you better check with your employment counsel. Now, one of the things that's the most, I would say, the most difficult for employers is when situations of intermittent FMLA leave. And sometimes I would say some of them aren't as difficult. For example, let's say I'm out for cancer treatment, and I know that I'm going to go for chemo on a Friday. I'm wiped out for Saturday, Sunday, Monday, Tuesday. I can come back to work on Wednesday, work Wednesday, Thursday, Friday, and the following week, and then I go out for treatment again. Typically, these chemo treatments are every 2 weeks. So there I would only actually be using up Monday and Tuesdays, every other Monday and Tuesday. That's an example of intermittent leave that tends to work pretty well. The situations that are much more difficult are situations where, for example, I get migraine headaches. And so I have a situation with a client where they're a doctor's practice and they have a pain clinic, and the pain clinic rotates on a biweekly basis. But on the day that I come in for pain clinic, I generate about $40,000 of revenue for the practice and for the hospital. But what happens is sometimes I wake up that morning and I have a migraine headache and I can't come in. The problem is other doctors can't jump in and see those patients because they're my pain clinic patients. So we lose all the revenue in those situations. And those can be very difficult situations for employers to deal with. But so you can take medical leave, intermittent leave, when it's medically necessary, and there are certain options that employers have. But what you need to know about intermittent leave is you can try to schedule it if it's possible. You can sometimes temporarily transfer somebody to an alternative position, but you can't force the employee to go out on a longer leave just because if they only need intermittently. So what other enforcement and protections do we have under the FMLA? Well, we can't discriminate against somebody for exercising their FMLA rights. So, for example, if I chose somebody for layoff because they didn't return my calls while I was out on FMLA leave, that would be a violation of the FMLA. And a corporate officer could be individually liable in those situations. These cases can be filed directly in federal court, and the damages include the income I lost plus attorney's fees, and they sometimes double the damages. So that is the FMLA. Now, there are other leaves that can run at the same time as the FMLA, like the Mass Parental Leave Act. That is, so employee goes out, has a child, and they go out on FMLA leave, but they're also going out on Mass Parental Leave at the time. So that could be 8 weeks of, again, it's unpaid job protective leave, and that would run concurrently at the same time as FMLA leave. In order to be eligible for parental leave, the employee must have worked for at least 3 months or through a probationary period of not more than 6 months. And generally those run together. Now, I'll give you an example of a time they wouldn't run together. Let's say that the doctor sends the employee for bed rest 12 weeks before her due date because of complications. She would then use her 12 weeks of FMLA up, and then when she had the child, she would then get 8 weeks of Mass Parental Leave. So there is a situation where somebody could actually get 20 weeks of job protected leave, but the timing would have to be exact for that to happen. Now remember, there's also what we have here in Massachusetts, the Small Necessities Leave Act. And that basically gives an employee, again, you have to be an FMLA employer of 50 or more, but that gives the employee 24 hours of leave for things like attending school conferences, routine medical appointments. And again, this is unpaid job protected leave of up to 24 hours, and you keep track of it based on the hour. And these are the sort of examples that you could use for that. We also have breaks for breastfeeding employees. And one thing that's clear is that you have to provide a reasonable break time and a private non-bathroom place. So a lot of employers just want to say, well, why don't you just go in the bathroom and pump breast milk? But the law requires that you provide another place. And I'll tell you, one of my favorite stories about a manager leading was in a company where there was almost no offices. It was a very open workspace. So the manager, to work with this employee, knowing it wasn't going to be for more than a year, told her that when she needed to pump, that she could come in and he would go out and work out in the common space with everybody else during those times so that he could have the privacy. And don't you think that won him a lot of points with everybody in the company, especially the other females? Okay, so now we have chopped off the FMLA head. The person has used their 12 weeks of FMLA leave, and usually before that time runs out, we like to send them a letter that says, "Dear Dave, your FMLA is set to expire on July 12th. If you may need more time and aren't able to return to work at that point, then we need further information from you." And so we now turn our attention to the ADA and also the Mass Handicap Discrimination Law, because if you're disabled under the ADA, you'd also be disabled under Massachusetts Chapter 151B. So what are the obligations of an employer in this case? Well, you can't discriminate against somebody who's a qualified disabled individual, and we have to provide them a reasonable accommodation if we can do it to allow them to perform the essential functions of their job, and it's not an undue hardship on us. So the ADA and 151B both impose a positive obligation on the employer, and we need to engage with the employee in a dialogue to see if they can perform the essential functions of their job with or without a reasonable accommodation. So, who's protected under the ADA and 151B? It's people who are qualified handicapped people that can also perform the essential functions of their job with or without a reasonable accommodation. If they cannot perform the essential functions of their job, then they're no longer considered a qualified handicapped person. So what's a disability under the handicap law? A person is disabled if they have a physical or mental impairment which substantially limits what the law calls one or more major life activities. So major life activities are standing, sitting, walking, things like that. Being able to see, hear. A person can also be disabled if they have a record of having an impairment, or if the employer regards them as having an impairment. So for example, I come back after all my cancer treatments and I am better, but you still treat me like I am not. That would be a situation where an employer would be regarding me as being impaired. All right, so let's just run through some situations. Which of the following would likely be considered disabilities under federal or state law? So we'll go through them, and I want you to say the answers out loud to yourself while I say them. Cancer that is in remission. No, unless the employer is still regarding me as disabled. A broken leg. Probably not. Although a broken leg, if you go out on, if you can go out on disability, like if you get STD for a broken leg, then yes. Substance abuse. Depends. If your use of illegal drugs is not protected under the ADA, so if it's prescription medication that you're taking and you're not following it, that may not be. But in general, illegal drug use is not protected. A minor back injury sustained while at work. Well, it depends. If you qualify for workers' compensation, then it is considered a disability under Massachusetts law. But if not, and it doesn't prevent you from doing major activities like standing, sitting, and walking, then no. A vision impairment that can be corrected with glasses. No, because in general, personal things like glasses don't fall under the ADA. Migraine headaches, yes, and an example of that would be the intermittent leave that comes up. So what are the things that make it a qualified disabled handicapped individual? So capable of performing the essential functions of a job with or without a reasonable accommodation. Well, what are the essential functions? Well, usually what we turn to in these cases when there's an argument is we look at the job description. And this is why job descriptions are so important, and it's so important to, in the job description, list what the essential job functions are. So that means the duties of the employment position that the individual with a disability holds or desires. It doesn't include marginal functions. The marginal functions are things that it's nice that they can do, but it's not critical. So for example, if I am the receptionist for a company and my job is greeting people and answering the phone, but sometimes they need me to carry heavy things, really my essential job functions are about greeting people and answering the phone. And that the carrying of something, probably somebody else could do that, or you could get me a cart so I could carry those heavy things on the cart. But that's the way to look at that. So how do you evaluate essential job functions? What are essential job functions? Well, how often are they performed? If you remove that function, does that fundamentally change my job? Again, what does the job description say? That's really important. And also, what would the employees holding that job say? So oftentimes, if you haven't done this, we'd like you to have the employees draft their job descriptions first and then have the managers look at them, because you may not realize they're doing certain things or they're not doing certain things as part of that function. But when we get into a dispute with somebody over the ADA and what is an essential function of their job, if you don't have a job description, then it's going to be an uphill battle for the employer. So we encourage you all to have job descriptions. So what is a reasonable accommodation? Well, it's anything that enables an employee to perform the essential functions of their position, but doesn't also cause the employer an undue hardship. So what's undue hardship? Well, it's a significant or difficult expense. It's something that's unduly disruptive, or something that alters the nature or operation of my business. So, for example, if I'm a truck driver and I go blind, we don't have to put Kara Brosnahan in the truck sitting next to me saying, "Watch out for that tree," right? So that's not something that would be required. So what are the things that would be considered accommodations? So permit the employee to work in a different location. Yes, that could be, and this comes up sometimes in a situation where employees out in a bullpen and there's a lot of distractions and they have, ADHD, for example. And if we move them to a quieter place and they can do their job better. Put the job instructions in writing. Yes. Provide an interpreter. Generally, no. Not required to do that. Reduce the standards of production? No, you're not required to do that. Transfer the employee to a different job. Well, if they agree to it, you could, but you don't have to create a job for them, and you also don't have to knock somebody else out of a job to do that. Create a new position for the employee. Again, you're not required to do that, but sometimes that is done. Modify the employee's work schedule. Yes, that could be an example. Let's say I have, and this comes up sometimes, I have a disease that I have to take a drug in the evenings, and it makes it hard for me to get up in the morning. So instead of me working from 8 to 4, one accommodation could be that you move me to 10 to 6, if that works for the employer as well. Now, that doesn't mean if I'm coming in late at 8 and you move me to 10 to 6, I still have to be on time at 10. Provide unlimited time off? No. You're never required to provide unlimited time off. Provide an employee with a new keyboard. Generally, yes. The cost of doing that is generally not that high, and so that would be probably yes. Provide an employee with new glasses? No. Again, we're talking about personal care. That is the employee. If we're talking about new safety glasses, for example, maybe. And sometimes employees like to have prescription safety glasses. Well, that would be something that the employer might split the cost with them, but otherwise the employer can just get safety glasses that cover their prescription glasses. Permit the employee to work from home. Yes, that is a reasonable accommodation, but it doesn't work for every job. If I'm the receptionist and I have to be there to greet people and answer the phone, then attendance at the job is an essential function of the job. So permitting me to work from home would not work. All right, how about this? Which of the following might an employer be required to do as a reasonable accommodation? Create a new position for the employee? No. Modify the employee's work schedule? Yes. Provide unlimited time off? No. Provide an employee with a new keyboard? Yes. Provide an employee with new glasses? No. Make sure the employee takes his medication? No. But the main thing that employers are required to do under the ADA is focus on engaging in a dialogue with the employee to try to arrive at a reasonable accommodation if they can. So once the employee requests an accommodation or the employer knows about it, that triggers our obligation to engage in a dialogue with the employee. And you're not required to adopt the employee's suggestion if there are other accommodations that are also feasible. So just because the employee wants a specific thing, if there are other ways to get at it, you don't have to do that. Especially if there are other less expensive ways to address it. And so the whole idea is you need to work together to try to arrive at that accommodation. In most instances, that dialogue is conducted by human resources and ideally not necessarily the employee's manager, although sometimes HR and the manager could do it together. Let me give you some examples of reasonable accommodations that work. So suggestions like maybe you need leave. An employer only has to provide as much leave as does not cause an undue hardship, and indefinite leave is not a reasonable accommodation. Job restructuring. Marginal job functions only can be modified, and an employee always must be able to do the essential functions of the job. What about light duty? And in a lot of workers' comp situations, the workers' comp carriers want you to offer light duty. Well, you're not required to offer light duty under the ADA, but you can create those positions for a temporary period. And if you do, I think you should put it in writing that this is only for a temporary period and usually set the time. And if they're not ready to come back after that, you may not want to continue it. Otherwise, the employee might claim after 18 months that, hey, this is my job now. Providing an assistant. That's fine as long as he or she doesn't perform the essential functions of your job. What about reassignment? Reassignment can be appropriate if the employee cannot do the original job anymore, but only to a job that the employee is qualified to do. Work from home, again, we addressed that. It's appropriate if the job can be done at home. And then modifying the work schedule, changing work hours or shifts or providing breaks or part-time work are all examples of possible accommodations. But the most important thing is not only engage in the interactive process, but document that you did it. Because as we say around here at Hirsch Roberts Weinstein, if you don't write it down, it never happened. And so after you have the meeting with the employee, it's always important to follow up in writing with them about what you've discussed or not. All right, so let's go to the true-false section here. And I'm going to ask a question. True or false? An employer has a duty to initiate an interactive dialogue with an employee if the employer has reason to believe that the employee has a disability. If you think that's true, you could raise your hand. Okay. And the answer to that is true. All right. So if an employee requests an accommodation, if it's job related and consistent with the business necessity, then an employer has, the dialogue really involves you accessing some of the employee's medical information so you can analyze the situation. So, but often we want to just submit that information to HR and only share it with management people who are on a need-to-know basis to address the issue. So if they can't perform the essential functions of their job, or there's a concern that the employee will pose a direct threat because of their medical condition, then an employer may not want to offer that particular accommodation. All right, we talked about GINA briefly. Now, Massachusetts passed a genetic anti-discrimination law in, I think, 1996, and the feds got around to it in 2000. But what is GINA? GINA says that employers with 15 or more employees are protected. And what is genetic information? Genetic information includes information about an individual's genetic tests, the genetic tests of a family member, as well as information about any disease, disorder, or condition of an individual's family member. Family medical history is included in the definition of genetic information because it is often used to determine whether someone has an increased risk of getting a disease. Now, this rarely comes up, but I will tell you a situation where I got a call from an HR director and said, the CFO called me and wants to fire our brand new receptionist, well, brand new, 8 month receptionist. And I said, well, how is the receptionist performing? And they said, well, she's doing very well. I said, well, what would be the reason to fire her? And he said, well, we're a self-funded plan, and it turns out her son has a rare genetic disorder, and we've paid over $400,000 in healthcare premiums and extra payments because of that. And I said, okay, well, if we fired her for that reason, then we would be in violation of GINA, and then they would come after us and they would win that case. So if she's a good employee, I think you just have to tell the CFO that that we can't do it. So that was sort of how that situation played out. But it doesn't come up that often. You know, most people aren't searching for genetic information about people that they're interviewing and hiring. Okay, so at this point, under the ADA, we've engaged in an interactive dialogue to determine whether the employee can perform the essential functions of their job with or without a reasonable accommodation. And we've either got them back performing with the accommodation, or they may tell us that what we're really looking for, if they can't come back yet, is something that says either the time that is going to be unreasonable, or that the doctor says their situation is, their current medical situation, it's indefinite about when they can return. And indefinite is about as good as it gets under the ADA, because every situation is case by case. But if they say it's indefinite, that's your get out of jail free card. And at that point, no employer is required to hold a position indefinitely. So at that point, we turn to and look at the workers' comp situation. So we've chopped those two heads off, the employees, and we're looking at workers' comp. So let me give you a brief history on workers' compensation. Back in the 1930s, before workers' comp law was passed, an employee working in a factory or at any job, if they got hurt on the job and they couldn't do the job anymore, they were basically out of luck. And there was no sort of income for them, and the employers would just terminate them. And so the idea was, the government said to employers, you need to buy insurance, so if workers get hurt, there is a process to protect them, and they can still get income. And the employer said, okay, but what do we get out of it? And the government said, well, in the law, we're going to make it clear that if they get hurt on the job, that the workers' comp benefit they get is the sole damages they can get against you, the employer. And so, for example, in a situation where I get my hand caught in a machine, I'll get workers' comp, and I can't sue my employer for that, but I might be able to bring a lawsuit against the company that manufactured the machine if there was a design defect or something like that. But so the trade-off for employers was, you buy the insurance, and the sole remedy the employee has against you is the workers' comp benefits. The only exceptions to that are if the employer does something willful or something outside the normal behavior. So workers' comp. We can't discriminate against somebody for filing a workers' comp case, but the only thing we actually have to do is they have a right to reinstatement and a preference for rehire if all else is equal. So if, for example, Karen Brosnahan and Jim McSweeney both had workers' comp injuries, oh, no, let's say that Karen didn't have the injury, but Jim did, and they both applied for a job at my company, ABC Corp., and they were both equally qualified, and Jim had worked here before and had been out for a few years because of his injury. I would have to give him a preference for rehire unless it turned out that Karen, who would be a new employee to me, actually had greater qualifications. So if she had better qualifications than Jim, which is probably true, Karen, right? Then I could hire her without any penalty. But if she and Jim were exactly the same, then I would have to give a preference to rehire for somebody who had worked for me before and had been out on a workers' comp injury. I want to say something about light duty because one thing that you need to understand is that your workers' comp carrier is your friend unless and until their interests differ from yours. And sometimes the workers' comp carrier wants to get the employee back on light duty. And the reason they do is that if they're back working, then the workers' comp carrier is not having to pay their wages. But sometimes you don't have a light duty job, or they may not be very productive or ready to come back on light duty. So we always say to employers, just be wary in these situations. Don't force light duty if you've never had it before, or if there's just not a light duty position for them to come back to. All right, so do you treat workers' comp as a special category? If an employee is on a workers' compensation and you first put the employee out on FMLA, right, and then you chop that head off, then you follow the ADA, and if there is a reasonable accommodation that they can do to return to work, you could do that. But once the FMLA and the ADA is played out, at that point, you're no longer, the workers' comp is operating separate and apart from that. The one thing you should know is under Massachusetts law, if you lump sum settle a case on workers' comp, and let's say you pay me, I'm in a terrible accident, and you pay me $45,000 in a lump sum settlement, then after a week or two, I come back and apply for a job. And you're like, well, wait a minute. And I thought your back was hurt. He said, no, I'm fine. Well, under Mass law, for every $1,500 that you spend in a lump sum settlement, the employee is deemed to be disabled for 1 month. So on a $45,000 settlement, they could not come back and apply to you for a job for 30 months, or 1,500 times 30, which is 45,000. And, so that's 2.5 years. So the whole idea was employers are protected in these lump sum settlements. They don't have to hire somebody back who's all of a sudden now claiming that they're better. And that was to prevent people from trying to game the system. All right, so let's go through a few scenarios here and test your knowledge. So Carl requests intermittent leave due to migraine headaches. Basically, Carl wants to take a day off anytime he gets a headache. Interestingly, he always seems to get headaches on Fridays and Mondays. Other employees have noticed and are protesting that they always have to pick up the slack for Carl. Assuming that Carl can submit appropriate medical documentation, is Carl entitled to take intermittent leave for this purpose? And then can you temporarily transfer Carl to a position that better accommodates his recurring headaches? And finally, you suspect that Carl is faking his headaches. Can you call his doctor directly? Can he get a second or third opinion? Are there any other practical steps you can take to address these concerns? Well, let's take these one at a time. Assuming that Carl can submit appropriate medical documentation, is he entitled to
intermittent leave? Yes. Now, if he's exhibiting a pattern of behavior of taking it on Mondays and Fridays, then you can question him about that, and we can also, if need be, push back on the doctor to see, is there a medical reason why it might be just happening on Mondays and Fridays and not on other times. Can you temporarily transfer him to an alternate position? Well, yeah, especially if the intermittent leave is foreseeable or based on planned treatment for the employee. The employer can move them to an available alternate position for which the employee's qualified and which better accommodates the recurring periods of leave. So absolutely, you could do that. And then we think he's faking. Can we call the doctor directly? No, but we can get and request a second opinion. Or even, and sometimes if there's a dispute between the doctors, we can even have a third opinion. So where an employer has reason to doubt the validity of a certification, they can require a second opinion at the employer's expense. The employer can pick their own healthcare provider, but it can't be somebody employed by the employer on a regular basis. And then third opinions are really, if the two parties disagree, there's a special procedure to follow for that, and those opinions end up being final and binding. So that's the way you might approach that situation. All right, let's look at our next one. The employee Nellie becomes pregnant. Nellie's job requires some heavy lifting. The company has a policy that pregnant employees in their third trimester must submit a doctor's certificate confirming their ability to handle the physical demands of the job. Is that policy legal? And so here, what are we struggling with? We're struggling with the issue of a blanket policy that that covers employees. And I would say that, and it's interesting because it's the pregnant in the third trimester and they must submit to the doctor's certification. I think you'd probably early on in the pregnancy want to give the doctor the job description anyway and find out what the restrictions would be, and I think the employee would want to do that as well. I don't like having a blanket policy that just says when we get to the third trimester you have to submit this, because the reality is it could be that that employee really shouldn't be doing any heavy lifting after the first trimester, for example. All right, let's go to this one. True or false, the law does not require an employer to hire, promote, or retain a handicapped person who cannot perform the essential functions of the job. And the answer to that is true. And that's because if they can't perform the essential functions of their job with or without a reasonable accommodation, and then they're not a qualified handicap. Now, this question asked, doesn't require the employer to hire, promote, or retain a handicapped person who cannot perform the essential functions of their job. If you said false, and you were thinking with or without a reasonable accommodation, then your answer is correct as well. So the point being here is this doesn't really state the standard. The standard of somebody being qualified disabled is, can I perform the essential functions of my job with or without a reasonable accommodation? If I can, then I am a qualified disabled and protected under the law. How about this? A rich employer is required to offer more extensive accommodations than a poor one. That is actually true. If I am a $100,000 a year business and you need a $10,000 computer as an accommodation to your medical situation, geez, that's 10% of all my revenue. That's different than if I'm IBM and $10,000 would be a rounding error for me. So a rich employer may be required to offer more extensive accommodations than a poor one. All right, how about this one? True or false? It's unlawful to fire somebody for absenteeism if the absence is caused by a bona fide disability. And the answer to that is yeah, if you're well, actually, the answer to that is I went to 3 years of law school. The answer is it depends, right? It's unlawful to fire someone for absenteeism if the absence is caused by a bona fide disability. Well, it depends. I mean, if I've used up all my job-protected leave and I still can't do the job at that point, then you probably can end my employment. So I think you have to look at the specific situation. All right, let's look at this example. John, a full-time exempt employee, has worked for you for 11 months. On January 1st, 2010, John gets into a car accident. He submits a note from his doctor stating that he needs to be out on leave for 4 months. Is John eligible for FMLA leave now? Well, is he eligible? He's only been employed for 11 months, so no. When would he become eligible? Well, actually in a month, after February or early February of 2011. If John is not eligible for FMLA leave now, do you still need to let him take the time off? Well, it depends. I mean, I think under the ADA, you might have a duty to accommodate him in the form of a period of leave. What if the car accident occurred while John was traveling from his office for a meeting in Connecticut? Well, commuting time is not considered in the course of your employment, but here traveling from the office to a meeting would be in the course of his employment. So therefore, that accident would likely be covered under the workers' comp statute. Assuming that you decide to give John the time off, how much time off do you need to give him? Well, what you could do is say to him, and this is what I would recommend in these situations, is say, John, even though you're not entitled to the FMLA leave, since you're going to be out for more than a month, you will become eligible. So we're going to start giving it to you right now. And that way you just give him the 12 weeks as opposed to waiting a month and then giving him 12 weeks. Now, what if John's not ready to come back April 1st? Can you terminate him? No, you need to then engage in the interactive dialogue under the ADA. You've chopped off the FMLA head, but you still have to deal with the ADA. And what if he doesn't come back by May 1st? Again, it depends. Under the if you've given him the FMLA leave early, then we're looking at an April 1st deadline. If you didn't, then we're looking at a May 1st deadline. But now his FMLA's run out. So again, you're engaging in an interactive dialogue at that point to see if he can return and perform the essential functions of his job. All right, so I guess we're now ready for the question portion of our event. And so Karen, did you have questions that you wanted? Let's see, everybody seems muted right now. Karen, are you unmute?
Hi, Dave. I think
there
we
you are.
did have some questions that
Okay.
came in on the pane, but it may be easier for you to look them
let me
over.
see. Can I make that bigger? I'm just reading one line at a time here. We're trying to see if we can make that section bigger. All right. Well, we'll let's see. I'm going to try to go to the top of these questions. Okay. So let's see. Which, yeah. Oh, so you are saying it is the company's choice if the employee uses any or all earned time before applying for leave. No, I'm not saying that. What I'm saying is, remember, FMLA leave is unpaid job protected leave. So once I qualify for that, as an employer, generally I think you'd want them to start running that FMLA leave time. When I was talking about earned time, is some employer policies require you to use your earned time, like your vacation or your PTO, during your FMLA leave, and others don't. And you can require that, but if I'm also getting, for example, workers' comp or getting STD, then you can't necessarily require it unless the employee agrees to it. All right, there's a copy about, can we get copies of the slides? Sure, there's going to be a, we will send out an evaluation form, and if you fill it out, then Karen will send you the slides after that.
Be happy to.
Okay. Oh, did we define qualified disabled individuals? Yes, a qualified disabled individual is somebody who can perform the essential functions of their job with or without a reasonable accommodation. So in other words, I may have a disability, but if I can still perform the essential functions of my job with or without a reasonable accommodation, I am considered a qualified disabled. All right, next question. My company actually has 3 employees going on FMLA maternity leave within the next 4 weeks at the same time. Does this mean they are all eligible for the, it's the mass parental leave law plus the FMLA? Yes, but those are going to run together at the same time. So generally, if there's not any pre-birth problems, somebody will have the baby. Let's say I have the baby today, July 12th. My FMLA leave and my mass parental leave would start running at the same time. And after 8 weeks, my parental leave would expire, and after 12, my FMLA would expire. All right. Let's see. During discussion, let's review migraines versus apparently legally labeled physical disabilities, please. Okay. So a migraine headache under the ADA is a valid disability. And if I hope nobody on this call has ever had these migraine headaches, but if you have, you know that they basically stop people dead in their tracks. They have to lie in a room with no light and little sound and hope that they go away. So a migraine is considered a disability under the ADA. Oh, on the second or third opinions, there was a question about who has to pay for those. The employer has to pay for the second or third opinions. And sorry for the siren sounds. That's what you get when your office is near a firehouse. Can you print out the information sent to you? Sure. Let's see. I'm just going through the last group of questions. Let's see. Did you say the FMLA is supposed to run concurrent with workers' comp claim? Yeah. Workers' comp really operates separately and apart. I mean, a workers' comp case can be settled almost immediately. They can also go on for a number of years. And so think of it, the 2 key ones really are the FMLA. You have to deal with that monster first. Then you switch to the ADA. And then when you're done with that, you can still terminate an employee even if they're out on workers' comp. It doesn't affect their eligibility at that point. Okay, I think those are all the questions we have. If anybody has any others, write it now or okay.
Dave, I
Karen?
want to thank you so much for the presentation today. We really appreciate it and all the information you've shared and your expertise. And
Well,
thanks to all the attendees for joining us.
yeah, glad to do it. CIP really knows what they're doing, so you guys are all smart to be working with them. And we will talk to everybody soon again. And so if there are other questions that come up, I think that you can submit them to Karen, and we'll get a survey out, and then when you've answered the evaluation, we'll get the PowerPoint slides to you.
Okay, great. Thanks, everyone. Have a great day.
All right. Bye-bye.